Last Tuesday, surprisingly quietly, if you ask me, I thought the story was going to be revived back to front page headlines. It really hasn't been, but 2 men were convicted on federal charges in the so-called Whitmer kidnapping plot that was busted up very conveniently just before the 2020 election. And recall, these 2 convictions were on retrial. The same cases were originally tried in April, including 2 other men. Those other 2 were acquitted outright. The jury found them not guilty. In the case of these 2, the jury was deadlocked. They couldn't reach a decision. A mistrial was declared, a new trial happened, and now you have the convictions from last week. And my initial rube gut reaction was, how is this not a double jeopardy violation of the Fifth Amendment? Because the Fifth Amendment says no person shall be subject for the same offense to be twice put in jeopardy of life or limb. But that seems like exactly what happened here. It's the same crime, the same facts, the same judge, the same case, the same jeopardy for the same offense as the Fifth Amendment would appear to prohibit. And the only reason this case returned is because the prosecution failed to prove its case sufficiently the first time around, and they just want another crack at it. So how is that square constitutionally? So I went searching for the answer in the context of this Whitmer plot retrial, but I was unsatisfied with the answers that I found. From news coverage of the first trial in April, a law professor is referenced as saying, quote, "There's no issue with double jeopardy here by retrying them, and the reason for that is because there was no conclusion. There was no final judgment, and so there was no conviction," for example. But there was a conclusion of no conviction. It's not the conclusion that the prosecution wanted, but there was a conclusion. Besides, by this reasoning, is there no single jeopardy unless and until a conviction or acquittal is delivered? How could that be? The whole trial isn't jeopardy, only the very end is? Now, of course, there is a distinct possibility, if not outright guarantee, that I'm just an unqualified dummy on this topic. But in every deficiency, there's an opportunity for improvement, so I figure I should learn the explanation for my question, or at least do the best job that I can. So I emphasize this is an exercise by a non-lawyer in self-education. Don't take any of this as lawyerly expertise. This is a pure layman attempt to understand some constitutional and legal technicals. If you're really interested in this topic, cross-reference it with your favorite lawyer. That's the first qualifier. The second, before we get into it, is that we should all put our personal views of the Whitmer plot itself aside. It's my personal view that these guys were entrapped based on the broad but near undeniable fact that this plot would not have happened but for Fed involvement from its inception. I've spoken at length on that topic in multiple videos. I've linked those videos atop the description if you'd like to revisit them. But even if you're of the opposite view, you think these guys are actual domestic terrorists who deserve the potential life in prison that they're facing, the question of principle remains. Is retrial after a hung jury double jeopardy or not? That's a question we should all care about, not because of this case alone, but because it's a crucial question on which hundreds or thousands of criminal trial outcomes a year depend. And lastly, for the constitutional purists out there, there's always a debate about the application of the Bill of Rights to the states through 14th Amendment incorporation. I will emphasize that debate, while personally very interesting to me, is not at issue in the Whitmer case. This was a federal retrial of federal charges in federal court. The Fifth Amendment applies to these trials as plainly and directly as possible. Now, if I haven't bored you with the qualifiers and the technicals yet, just wait, I'll get there, because this question of how a retrial after a hung jury is not double jeopardy is, unsurprisingly, a pretty technical one. It involves jargon and imaginative reasoning, not quite on the levels of the emanations and penumbras that somehow brought us a supposed constitutional right to an abortion, for example, but not too distant from that either. The Fifth Amendment is not explicitly clear about what legal jeopardy is, when it starts, when it applies, what defines it. Without knowing what exactly legal jeopardy is, we can't know what double jeopardy is. And so, as usual, our system relies on Supreme Court history on the matter. And that history is nearly as old as our Constitution itself, or at least the current standard that's been interpreted is. The standard that retrial after a hung jury is not double jeopardy dates back to an 1824 Supreme Court case called United States versus Perez, in which a man was tried on piracy charges, the jury was deadlocked, the judge declared a mistrial, and the pirate man was retried and convicted. In this case, the Supreme Court said the trial judge was justified in declaring a mistrial because a deadlocked jury creates what the court called a quote-unquote manifest necessity to end the trial. In more plain terms, That's a situation in which you must end the trial because there's just no way around it. There is no alternative. And ever since, the Supreme Court, and now by extension every other court in the country, has interpreted that case to mean that a retrial after a hung jury is not double jeopardy in violation of the Fifth Amendment. But there are problems with that interpretation, problems that have put this conclusion drawn from Perez at odds with the rest of the Supreme Court's double jeopardy standards developed since, creating a complete contradiction as to why the Supreme Court says that a retrial after a hung jury is not double jeopardy. The problems begin because Perez, strictly speaking, was not actually a constitutional double jeopardy case. It was a case about criminal trial procedure, a case about when mistrials can justifiably be declared, a hung jury being one such example. How do we know? Because the Perez decision never mentions the Fifth Amendment at all. It never mentions double jeopardy either, because those questions were not evaluated in that case. And if you think the absence of these references in the text is insufficient to say that it's not a double jeopardy case, well, Supreme Court Justice Joseph Story, who wrote the Perez decision, later wrote in another opinion, sitting as a circuit judge, that it was not. He said the issue of double jeopardy was not before the court and was not at all examined in Perez. So it's not me saying that Perez was a criminal procedure case, not a constitutional case. It's the justice who wrote the opinion saying that. It's just that the Supreme Court has jumped to a conclusion from it ever since and said the issue of what this case actually evaluated is, quote, of academic interest only. But as we saw last week, it isn't. Whether Perez was in fact constitutional law or just trial procedure, whether Perez does or does not say what constitutional retrials are, that's the difference between freedom or potential life imprisonment. And on that point of it not being a constitutional case, Perez never mentions double jeopardy because legal jeopardy was understood differently at the time. In 1824, the standard according to English common law was that jeopardy only attaches when the jury reaches a verdict. But since the Supreme Court has rejected that standard and in the 70s established the standard that jeopardy actually attaches when the jury is sworn, which understanding is constitutionally correct according to what the framers intended is a little beyond my expertise, but the court's reasoning that jeopardy describes risk doesn't begin at conviction. Risk begins with the process that leads to it, as in the trial, and the jury sworn to decide it. That's sensible and text faithful to me. In other words, a conviction is the realization of jeopardy. A conviction is not jeopardy itself. I'm not in jeopardy of being shot if the bullet has already hit me, for example. I'm in jeopardy when the gun is pointed. In the context of a courtroom, that's when the trial begins. Even if I'm mistaken, the point for our purposes is that the old case Perez assumed that jeopardy begins with either a conviction or an acquittal. Current cases since have said that jeopardy begins with the trial itself. There's a contradiction there that the court hasn't fully settled. If jeopardy in fact begins with the trial, well, then we have the question of what types of mistrials are constitutionally prohibited from retrial, and the court has issued dozens of decisions on that topic, balancing a defendant's right against double jeopardy with the state's interest in prosecuting and convicting criminals. Which brings us to our last problem with Perez, or at least how Perez has been interpreted. This manifest necessity standard that Perez established prohibits that analysis with hung juries. Perez says in cases where a trial meets a manifest necessity to end, where some circumstance arises such that ending the trial is the only option, as is the case with a deadlocked jury, then the judge is justified in ending it, and per the old standard of jeopardy only at conviction or acquittal, the case can therefore be retried. But the problem with this framework is that it treats all forms of manifest necessity or a necessary reason for the trial to end as the same. A tornado comes through town, destroys everything. That's a manifest necessity to end the trial. Try again later. The jury gets exposed to information from some outsider they shouldn't have heard. They can't unhear it. That's a manifest necessity to end the trial. Try again later. Or in this case, the jury is deadlocked. They simply will not agree. That is a manifest necessity to end the trial. Try again later. But one of these things is not like the other. In the case of the tornado, an act of God prevented the prosecution from getting their full and fair chance at conviction. In the case of the jury hearing improper information, outside meddling prevented the prosecution from getting its full and fair chance at conviction. In the case of the hung jury, nothing prevented the prosecution from getting their full and fair chance at conviction. They just didn't use their chance well enough. Indeed, this exact principle is what guides the rest of the Supreme Court's case law on the entire double jeopardy issue. In other scenarios where a mistrial is declared, the court balances a defendant's Fifth Amendment right against double jeopardy with the state's interest in prosecuting and convicting criminals, just not with hung juries, because Perez declared them manifest necessities. In other cases, the court has given explicit definition to the competing rights and interests at stake. The defendant has a Fifth Amendment right against the strain, financial, emotional, and otherwise, of repeated attempts at prosecution for the same crime, and a right to limit the risk of improper conviction. And the state, just as importantly, has an interest in pursuing criminal convictions, and is thus entitled to a full and fair opportunity to present evidence to an impartial jury, the court has said. So how do we determine what retrials are constitutionally square? Well, we look at whose rights were fulfilled and whose were not. In other contexts of mistrials and retrials, retrials because of prosecutorial error, retrials after convictions reversed on appeal, cases that are dismissed and retried, the distinguishing factor in whether the prosecution gets another chance is whether the prosecution already had a full and fair chance or not. In the case of a prosecutor failing to bring a key witness, the Supreme Court said that a retrial was barred because the prosecution had its full and fair chance. It just failed to do a good job with it. In another case of an indictment having a jurisdictional error that could only be fixed with retrial, the Supreme Court allowed one because that was more of a clerical mistake than some botched evidence or argument by the prosecution. Okay, but what's the difference, you might wonder? Those both sound like prosecutorial mistakes, so why is one okay but not the other? It depends on whether the matter would lend itself to prosecutorial manipulation or not, the court says. In the case of a missing witness, the prosecution has an opportunity to improve its case for next time if a retrial is allowed. In the case of the indictment error, the prosecution's case would remain unaffected. The guiding principle here, as the court has consistently held, is that the prohibition against double jeopardy unquestionably forbids the prosecutor to use the first proceeding as a trial run of his case. Yet in the case of a hung jury, that is exactly what happens. The prosecution didn't do a good enough job the first time, so they learn their lessons from the practice round and they try again with the new advantage. In all other contexts, the Supreme Court has said that is a Fifth Amendment double jeopardy violation, just not with hung juries for no logically consistent reason, just based only on a mistaken reading of a case from 200 years ago that never even claimed to address this question that we think means a tornado is constitutionally the same thing as a prosecutor doing a bad job, but it isn't. The court has said that prosecutors don't get practice rounds, yet in this context, they do. The court has said that when prosecutors get a full and fair chance at conviction, the accused enjoys a right against retrial, yet in this context, they don't. Say nothing of whether you agree with my persuasion that retrial after a hung jury ought to be barred. As I mentioned, I'm just some idiot who's trying to understand, but through its adherence to Perez, the Supreme Court has created an illogical mess of incoherence whereby a hung jury is some special thing exempt from the rest of the Supreme Court's reasoning on the topic for no reason other than they think they heard someone say that 2 centuries ago, even though that guy is clarified, no, you did not. So whatever the correct constitutional conclusion is, the court has to do some cleanup on this one because the current standard makes absolutely no sense. It's just this but not that, and that but not this, based on reasoning with no reference to the constitutional text itself. But let's leave the technicals and return to where I admittedly belong, which is the layman debate about where these lines should be drawn philosophically, not according to legal technicals or precedent. Whatever rules you design about when retrial is okay and when it isn't will create errors. You will have guilty people going free. You will have innocent people wrongly convicted. The question is, which error is better to accept? And I think the answer is clear. It's the same reason our entire system is built on a presumption of innocence itself. Innocence must be the default because the consequences of assigning guilt wrongly are not just an absence of justice, but additional injustice, injustice compounded, not justice ignored. In simpler terms, the guilty going free is one injustice, the injustice of no accountability for that crime. The innocent being punished is 2, the injustice of the original crime to the extent there was one, plus the additional injustice of punishing the undeserving. Now, I'm not advocating for either outcome, either the guilty going free or the innocent being punished, but if I have to pick, I will take a limited government with a higher bar for putting you in prison than a government unleashed to do it on a whim, or to do it with as many tries as they want, protection against which is exactly why we have the double jeopardy principle constitutionally enshrined. When the prosecution gets a full and fair chance at conviction, they do not get a second. But until the Supreme Court revisits this issue, they actually do in this particular context. So until then, remember, the best protection against double jeopardy is just don't listen to that smoke show honeypot who wants to smoke weed with you and talk about the boogaloo. And my, what luck, she has a hotel room right down the street. Just say no thank you, ma'am. There's a manifest necessity that you and I never speak again. Thanks as always for listening and for supporting this channel. Always appreciate that thoughtful discussion down below, and especially over on Gab. That is at ML Christiansen. You're always welcome to coming out and chatting my live streams. Those are linked down in the description. Looking forward to it.